But yeah, so we'll keep an eye on that. And that kind of brings us to our last story, because we have a court ruling, limited as it may be, from the highest court in the land. The Supreme Court finally made its decision in the ongoing saga over President Biden's ghost gun rule, where the Supreme Court gave deference to the DOJ and is going to allow that rule to be enforced while the litigation keeps going.
Yeah, they issued a stay and they gave us a whole paragraph to work with on trying to interpret their what they're doing with this. Basically the order just says we're issuing the stay, and that the stay is going to remain in place not until the Fifth Circuit gets done with this case, which is interesting, but until the Supreme Court decides what they want to do with this case. If the stay says if they decide not to take the case, then the stay goes away, but immediately. But there's a number of ways you can look at this one. I wrote a whole members piece on this, right? And you could look at it from a pro-gun rights advocate point of view or a pro-gun control advocate point of view. And you could come out with evidence for either side, I think. Because, here's the thing, right? We've talked about the Supreme Court and emergency interventions twice before in gun cases, right? And what did the court do then?
Right. Yeah, they decided to give deference to the lower courts and not intervene.
Yes. And what did they do this time?
Right. Now, all of a sudden, when DOJ comes calling, it's suddenly a little bit of a change in attitude from the high court.
Mm-hmm. And they decide that actually we're going to get involved in what the lower court is doing and issue a stay.
Right.
Of course, there's another point on this end, which is that if you look at the stay, they also mentioned who didn't want to issue the stay, right?
Yeah.
And it was all conservative justices, right?
Right.
Four of them said no. It was Gorsuch, Kavanaugh, Thomas, and Alito. They all wanted to say no to the stay. So Roberts and Barrett are the ones who joined with the three liberals on the court to issue the stay. So that's a bad sign if you're a gun rights advocate, because this split the conservatives on the court and didn't split the liberals on the court.
Yeah.
Maybe that says something. It also has the court going against the Fifth Circuit's determination that the stay wasn't necessary because blocking the rule actually reverted things back to the status quo, because the rule was what changed the status quo in the first place. So that's something. Those are things to go off of. Of course, the other hand, you have a number of things to consider. First of all, it's not a Second Amendment case, right? This is obviously it deals with gun policy, but the claims aren't Second Amendment claims, at least not the ones that the courts have actually ruled on.
Right.
This is administrative powers, right? This is the Administrative Procedure Act is the key bit in this case. And so, it's not actually a Second Amendment case. That's one thing to note. Of course, the court has been equally skeptical, maybe even more so, of administrative power, executive branch power in recent years. So I don't think that's any more fertile ground for people trying to defend the ghost gun ban, but it is a key difference. And then, of course, like you mentioned, one of the big differences, in my view, is that the government was the one requesting the emergency action in this case, and they're requesting a stay instead of an injunction, right? And so those are two different things. The previous gun cases, those were both plaintiffs requesting injunctions or requesting for a stay to be lifted in the New York case, and the court didn't want to get involved in blocking a law in that way, I guess. And they're much more likely to default procedurally to what the government wants to do. This is one of the reasons that you saw very few Second Amendment cases between, Heller, McDonald, and Bruin, because the government wasn't appealing any of those cases. They were winning all the ones at the lower courts.
Right.
And so, the court could have taken, of course, they do take cases from non-government, plaintiffs or defendants, but they're very deferential to taking cases from the government, especially the federal government. And so that's why you saw Rahimi happen almost immediately after Bruin.
Yep.
Because it deals with a federal law that's been blocked or struck down. And it was a request from the federal government. And so that's why you might see a greater pace of cases coming forward out of all this. But,
yeah,
what does this all mean for the merits? I don't know. It's certainly not what gun rights advocates wanted to see happen, right? Clearly. But it's not something that it's like, oh, well, they're obviously going to side with the government in this case, or even that they're obviously going to take this case up if it does, once the Fifth Circuit does issue their ruling.
Right. Yeah. No, like you said, it is an unusual thing that they stayed it even despite whatever the Fifth Circuit will eventually rule. But as you said, that's no guarantee that they're going to then come in and take the case. They could just say, we like what the Fifth Circuit did, we'll deny cert, and then that's sort of that. So it's sort of just kind of up in the air right now. We'll just kind of have to wait and see.
And even if they did take it, I wouldn't think that necessarily means the government's going to win.
Yeah, agreed.
On the merits. I would still think they're more likely than not to rule against the ATF in this case. But we'll have to obviously wait and see. They could, if those 6 justices that issued this stay wanted to say something about the merits or even hint at what they think on the merits, they could have done that. You kind of saw this in how they handled the New York emergency application, right? The plaintiffs in that case wanted the Second Circuit stay removed while the case was being heard. And the Supreme Court said no, but Alito and Thomas wrote a concurrence in that case that mentioned, we're just doing this to, let the procedure play out in this lower court. But we kind of like the ruling, right? I mean, they compliment the ruling, go out of the way to say something about how they like the ruling against New York's law. And, obviously that's just 2 justices, but it's, it gives you perhaps some insight into at least the conservative wing of the court in that case. Whereas in this one, nobody said anything. And the conservatives who dissented didn't say anything either. So, it's hard to read the court. You can't, these are all tea leaves, right? I don't want to get too far out over the skis here, but their silence could say something that basically if everyone was already decided on the merits of this case, which presumably they wouldn't do before they actually heard anything on it, but you might have seen a little bit more coming from the justices than you did. This may just be limited to a disagreement over whether the stay should have been in place, because the Fifth Circuit not giving them one is a bit unusual, I think.
Sure.
You often see the government get stays in these sorts of cases while the litigation is ongoing. So, and the court might just be sort of reestablishing the status quo as they view it. But we'll have to watch and see exactly what happens.